Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
Ladies and gentlemen, thank you.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti. I'm here to discuss the Idaho 4 case. And you know, this is going to be kind of interesting because I have suspected for a long time that the way things went down when the plea was entered in the case, there was just a whole lot around it that just didn't make sense. There was a lot of suspiciousness, I guess I should say. And the fact that there was a big time leak from somebody likely with the state to Dateline, and they were manipulating all the information to make it look like it was worse than it was, and apparently lying about most of it, and really, I would say, prejudicing that jury pool to an extent to which Bryan Kohberger would have never got a fair trial. The defense asked for a special prosecutor, investigator to be assigned by the judge. Judge agreed. But then the judge denied the continuance, which was very strange considering all the circumstances around it. And then a plea deal ensued and nobody could figure it out. And then there was the actual plea hearing where Bryan Kohberger just said yes to the charges and wasn't forced to allocute in any way. And then I watch, for example, the Gilgo Beach psycho man. And turns out he was that psycho man. And not only was he willing to admit to what he did, but give specifics, but he's even going to work with the FBI's, psychoanalysis team. Give me a break, as if they can really learn any more than they need to know from these guys. And he's going to work with them on how to, investigate cases in the future regarding people like himself. So comparing that to what happened in the Idaho 4 case, it's just night and day. And I think to myself, man, what could really be going on in this thing? And then we know, I've said it 100,000 times now, that this thing is far from over. That this thing will go to trial. We're looking at all the information now, and it seems like it's always been a plan, but we just have been waiting to figure out how it was going to happen. And then I've speculated, and others have speculated, once the leak investigation is over, that's going to be their way back into a trial. And no matter what I say, everything I look at still says, that's a pretty tough thing to do. But I believe that with there not being a precedent of a situation like this, that once it's complete, people will have to listen and things would have to take place. But then I stop and think to myself, because of all of the secrecy in this case, all the backdoor dealings that we've had in this case, and previous experience that I've had in my life, I wonder if maybe there was backroom deals, that we're just not privy to, that nobody would be privy to because they would be off the record, such as, plead guilty now, and then we'll give you a back door into getting a trial down the road. That way we all look good, y'all look a little bit bad, but everybody gets what they want in the end. And I think about those things because I remember I had a pretty serious traffic violation one time, and I was, in my humble opinion, not responsible for the charge that was against me. And my attorney in a pretrial hearing was tearing the officer up and the state prosecutor, just tearing them up. And at one point during that pretrial hearing, the judge actually stopped the proceedings, asked for both attorneys to meet with her in her chambers. And they did. We were wondering, like, I wonder what the heck's going on in these chambers. Maybe it's good news. And then when my attorney walked out of those chambers, he didn't have a very happy look on his face. And he walked up to me and he said, okay, so this is off the record, the judge said, but she said, no matter what I do, she's going to find you guilty. So if we're going to take this route, then we might as well plead guilty and then worry about it in appeals. And I was like, dang, can they do that? And he said, well, she did it. So it let me know that these things are quite possible, and not only possible, probably happen on a regular basis. Probably the judge and the attorneys go into little rooms where nobody's paying attention, and they make these kind of backroom deals. And I'm not saying that happened in this case, but I'm saying it's quite possible that it did. So I start thinking, how would they undo what they've already done? And I think it's quite a bit of a possibility that we've already seen the roadmap for this.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
And before, when the state was arguing for the restitution in the case, and the defense was arguing against it based on valid arguments, the judge started making those statements that we all found to be quite interesting when he said, well, are you in violation of the plea agreement because of this? And the defense said no. And could that have been a way? Is that something that they've already made a deal on? Is we'll violate the plea agreement because of restitution in the case, and the first time they brought it, the defense wasn't ready, so they said, no, this isn't in violation of the plea agreement. But if there's a second go around, maybe the second go around when the judge says, are you in violation of the plea agreement because you're arguing this, maybe the defense team will say, yes, we are. And the judge rescinds the plea agreement, and then a trial would be set if that happened. And I just find that to be really interesting when I look at this. Yes, if a judge rescinds a plea agreement due to a violation, the case typically reverts to its original status, which often means a trial date will be set. Because plea agreements are treated similarly to contracts, a breach by the defendant allows the court or prosecution to void the deal entirely. Yeah, this is kind of outlandish. Are you thinking this way, Pob? Why would you even bring this up? Well, because lo and behold, when I look at the case summary for the Bryan Kohberger case out of Ada County District Court, and I'm looking at the last time the judge made the order for unsealing documents, and now I notice there's some new things on this case summary, and it's just very interesting to me. And it was a motion filed on March 19th, 2026 by the state. And it's a motion to amend the order of restitution. Motion to amend the order of restitution. Now, we've already had a restitution hearing where the judge and the defense I just showed you were arguing the amended restitution, and that was supposed to be done, and it's been months and months and months. So what is this new motion by the state? And then on March 20th, it says amended, state's amended motion to amend the order of restitution. So they filed an order to amend the restitution, then filed an amended order to amend the restitution. This is kind of similar to what happened last time. And then on April 2nd, apparently, the state's request for decision without a hearing. But then on April 3rd, we have a defendant's response to state's motion to amend the restitution. This is kind of the same playbook that happened before. And it resulted in a hearing like I just showed you about the restitution, where the judge asked the question, are you in violation of the plea agreement by arguing this? Is this an argument by the defense against this amended restitution? Because if it is, the judge could ask the same question. This time the defense could say yes. Now, having followed the previous amended restitution request by the state and everything that ensued from that, I find it very, very interesting that we now are doing this again as it relates to the restitution. Of course, these things have not hit the actual court register yet for us to be able to read what these motions by the state actually say and the response by the defense actually say, because it sure takes a long time for things to hit that open register there in Moscow for us to understand what's going on in the case. But apparently there are things going on in this case behind the scenes that, well, we now know are going on behind the scenes. So everybody thinks this thing's over. And I've said for a long time, folks, it's far from over. Is this the way back in? I'm not sure. But when I think it all through, it certainly looks like a way, in my opinion. And if it happened, you can bet if this happens like I'm saying that it possibly could, then there is no way that this deal wasn't made in closed doors before the actual plea agreement was ever put into place. So they're not going to fool us, and I'm not going to let either side fool us in this thing. Please like and subscribe to this channel. Post your comments, your thoughts, your criticisms. Until next time, Pavarotti's out.